students, I like to continue with the same aspect of party autonomy. Additionally, I do have a role to mention about what the court has to say in an arbitration. Before the break, we looked upon multiple aspects about party autonomy. But generally speaking, the category or items like which are all can be coming under the party's autonomy is that: one, determination of issue; two, choosing the rules and regulations, including the other conditions in the arbitration agreement; three, there is a right entrusted to the party when it comes to objecting the happenings of the arbitration proceeding. I'll anyway try to explain. Four, minimizing the scope for judicial intervention. This is also party autonomy in arbitration. The judicial intervention's scope is very limited. Literally, you can say no scope for judicial intervention. Fifth one, administrative assistance, that is choosing the institutions. Sixth one, the procedure to be followed, overall procedure to be followed by the arbitrators in conducting the proceeding. 7, the place. 8, the language used in arbitration. 9, the procedures like documents only, that is a fast track. And obviously, the last one is on when to conclude the arbitration proceedings. That's technically or legally it is called the termination of the proceedings. Additionally, when it comes to looking into parties' autonomy with respect to arbitrators or the arbitral tribunal, the earlier 10, what I mentioned is that parties' autonomy on the procedures, issues, rules, right to object, judicial intervention, administrative assistance, general procedures, place, language, fast-track procedure, termination, all these are confined to the party autonomy in arbitration procedure. There is also a component of party autonomy with respect to arbitrators or the tribunal. Here, the categories are like the number of arbitrators, the procedure on appointing the arbitrators, the procedures on challenging the arbitrator whom they have appointed. It also includes on the procedure or what procedure they have to agree. That also is parties' autonomy regarding challenging the arbitrator. And the list also includes few more. There are 3 add-ons. 1, party autonomy regarding the arbitrators, particularly approaching the court for seeking setting aside of an award. It is not that the parties can always or have to agree on the award. The parties have always an opportunity. If something has gone wrong in the arbitration, they have the autonomy. Here, both the parties or one of the party also has autonomy to approach the court seeking setting aside of the award. Further, the court also, the party autonomy also is light on extending the time limit for giving the award. The new amendments in the arbitration law confines on certain time period. as rightly by the moderator, the initial remarks when he was trying to express that arbitration also sometimes is prolonging, it was a real fact, a true fact, even though the 1996 Act was to the international standards. But to overcome that, in 2015, a time frame was brought in for domestic arbitration also to complete that arbitration within 12 months with certain add-ons front and back. Here, if an arbitral tribunal is not in a position to conclude that arbitration within that prescribed time limit, that is 12 months, there can be further extension at the choice of the parties or the autonomy of the parties. The further extension of 6 months to the maximum of 6 months, the parties can provide that to the arbitrator. That is the greatest autonomy, because they need to have the conclusion, even though there has been a delay in that particular process, for a further 6 months is permitted under the law, but it is at the choice of the parties. And the final aspect under the party autonomy pertaining to the arbitral award is settlement, which I highlighted, that the parties at very well during the proceedings can settle the issue, and if needed can ask the arbitral tribunal to record that settlement by way of an award on agreed terms. These are the overall structure, what you can understand looking into the arbitration as such in this country. If you look into specifically on the court, unless otherwise agreed by the parties clauses. If you look into the Bare Act of this Arbitration Conciliation Act, most of the provision starts with unless otherwise agreed by the party. When I was mentioning about communication, addresses for communication, here also starts unless otherwise agreed by the parties, the arbitral tribunal shall. That's how it starts. And here, the key element for us to understand the limitation arises on one aspect, which is called date of commencement of arbitral proceedings. When does an arbitral proceeding commence? As party, they have an autonomy, no doubt. They can fix that this is the day when the arbitral proceedings is actually commenced. But we can't expect a person's having very limited knowledge on law or the legal principles to even agree on this. But the provision says, unless otherwise agreed by the party, the date of commencement of the arbitration proceedings is the day when the notice of invocation of arbitration is received by the other party or the respondent. This is purely a procedural one, determining when an arbitration commences. If we have time, when you're going to look into section 21 of this Arbitration Conciliation Act, it is a simple provision, commencement of arbitral proceedings. But this is under the party's choice. If it is not agreed, then it is as per that particular provision stating that the day when the other respondent receives that notice, or it is served on that particular respondent. Further down the line, some more aspects which also includes with unless otherwise agreed by the party clauses. In arbitration, we need to file pleadings, other documents which are very essential, which makes the arbitrator understand the case of both sides, which is in a legal language, the pleadings. Here, the party autonomy is not on the documents as such when it has to be made. It is on the element required in the statements to be submitted and the time limit for making that particular submissions. Two documents predominantly has to be filed according to the law in arbitration under the heading pleadings. One is a statement of claim, another is the statement of defense. Like our normal, we are saying that CPC is not applicable, but still the arbitration law, which has been taken from the model law, also says about two documents, statement of claim, statement of defense. It is similar to our plaint and our written statement. Nothing special, same thing. And in the same law, there is a component of how to structure these documents or these documents is mentioned. They're saying that the facts of the case, points at issue, and the remedy sought. These three has to be there in the statement of claim. I'll repeat. Facts of the case, points in issue, as well as the remedy sought. In plaint, what we have, the same thing, facts of the case, issues which has to be dealt by the judge, and finally prayer, that is a remedy what we are seeking. The same has been laid down in the model law which has been adopted in our country arbitration law also. And here, the particular provision which is highlighted under section 23 says that you can also agree. That is, the parties can also agree. The party's choice is there. The party's autonomy is there. How a statement of claim as well as a statement of defense has to be filed. But there is a time limit. But that time limit, in a general perspective, reading that particular provisions, we can understand that the pleadings, that is a statement of claim and defense, has to be filed within 6 months from the date of the arbitrator receiving the letter confirming his appointment, whether sole or the third arbitrator. The elements required in a statement, party's choice, but the time limit wherein those documents has to be filed, the time limit is given 6 months from the date, which is a mandatory provision, which is not straight away given to the parties. But still, that provision starts with the court unless otherwise agreed. That means those parties can very well agree within the time frame of 6 months to conclude that particular documents to be filed before the arbitrators, with the elements what they feel which has to be included has to be submitted before the tribunal. Interestingly, it doesn't stop there. It also extends to another component. Earlier we saw oral hearings. And I also suggested that it is not always to have oral hearings. We can also have documents only proceedings. Similarly, when it comes to briefing or submissions, we can also have the arguments done orally. Oral arguments, it is at the choice of the parties. Unless otherwise agreed by the party, then the arbitral tribunal is going to fix this is how written argument, oral argument during oral hearings, documents only, procedures, all these comes into play. But one thing we have to be very seriously taking into consideration as lawyers, when you are going to advise the parties have the greatest freedom. Legally, they might be wrong, but they have the greatest freedom to participate or even not to participate in an arbitration proceedings. They have full freedom. But as lawyers, we are going to advise them, you have to participate, because this also is a proceeding which is under the behest of a law which has a equal status and scope to that of a normal proceedings happening in the courts. This is our responsibility, but still many parties avoid participating in an arbitration proceedings. Even if they participate, they'll just observe. They won't file any documents on their behalf. It might have drastic consequences, but as a basic principle, unless otherwise agreed, that is a party autonomy, the consequence of non-participation or non-cooperation of the parties in an arbitration might have certain effects. If you look on the subsequent provisions, that is 25, which speaks about default of the parties, there are 3 circumstances. These are consequences. They have to look into these consequences, and accordingly they have to go with their autonomy, exercising their autonomy. 1, as a party who is commencing the arbitration, who is called the claimant, once he commences, his responsibility is to file the statement of claim. If he is not filing the statement of claim, the consequence is termination of the proceeding, entire arbitration. There can't be arbitration. Secondly, the claim is filed, and on the side of the other party, the respondent, they have to participate and file the statement of defense and supporting documents. They are appearing but not filing, then they are forfeiting their right to file their reply, and obviously the arbitrator would be forced to go with an arbitral award on merits. That also the law says. And thirdly, the other party, that is a respondent, is not appearing, not filing any documents, that is total non-cooperation to that arbitration proceedings, then the consequence is that an ex parte proceeding. The word ex parte is not used, but there is high possibility of accepting the provision which says that the arbitral tribunal can proceed with the documents which is available with it. Obviously, the one document, statement of claim with supporting documents are there. No defense supporting documents are there. Obviously, it is going to be an ex parte decision. We can't later raise this. It is the responsibility of the parties to participate. But even in this provision, it predominantly starts with the quote, unless otherwise agreed by the parties. The parties can also very well agree for it. Here, there is one new, or we can also say in the courts also, we do have the practice of appointing expert. Many of our cases, we do have the experts appointed for our party to establish certain issues. If you are dealing with some lease agreement or regarding some properties, there is high possibility of valuation report to be filed. As lawyers, we don't have that knowledge or expertise to prepare a valuation report. A valuation report has to be prepared by an engineer who is also an accredited valuer. That person is the best person to provide it. At that stage, we bring those person as an expert, and that expert report would be filed in the courts. Similarly, in arbitration, also experts' role is there. And here, the party autonomy is also evident by the word that the parties can very well appoint expert on their behalf. And further, it also goes and stretches that the arbitral tribunal can also appoint an expert. If the arbitral tribunal wants to understand certain issues, they can appoint And that clause also starts with unless otherwise agreed by the parties. Here, an arbitrator needs to get an assistance, and the arbitrator is not depending on the parties' assistance, the experts appointed by the respective parties. The arbitrator wants to have an independent expert. All these party autonomy we can see, which is also given in the law itself. But whether these also goes with certain limitations or responsibilities. Yes, as I earlier mentioned, the limitation is there, the responsibility is there, or the duties is there for that parties as well as the perspective of an arbitrator to some extent. As party autonomy, it is like Newton's third law of motion. They do have certain effect to it, and that effect has to be cautiously facilitated or defended by the parties with the help of legal persons or legally qualified professionals. Okay, this is one part, party autonomy. The another task given to me is what is the role of court. I'll just try to complete by 10 or 15 minutes before the scheduled time so that we can have Q&A session. Role of courts also is there. The first session, the training session by Mr. Anil, you would have understood that the courts have no say. Entire arbitration is happening outside the court. It's an acceptable fact. It is happening outside the court. But still, when you look on this model law or the Arbitration Conciliation Act of our country, there are certain provisions which facilitate courts to take up certain role. What are the roles? And there is one provision. If you can look into the provision, section 5, which speaks about court or intervention, judicial intervention in an arbitration. To what extent the courts can intervene in an arbitration? You need not worry, oh, court is intervening means it's going to stop. It is going to inject the arbitration. No. No court has an authority to intervene in arbitration. The word intervention is used synonymously to facilitation of an arbitration or assistance of an arbitration. The courts are there to assist whenever there need to be an assistance from a third agency for that arbitral process. If you're going for institutions, you need not worry. We can get the assistance from that case managers of that institution because their rules facilitates that. The role of courts is there to just help it out. According to my general research and experience, limited experience in arbitration, 5 sections are very important. 1, section 8, 2, section 9, 3, section 27, 4, section 34, and 5, section 37. 8, 9, 27, 34, and 37. What are these? 8 we saw. If there is an arbitration clause and unfortunately or intentionally or out of ignorance, if one of the party approach the court and file a civil suit, then if the court is being brought to the notice of existence of an arbitration clause, then the role of court is to refer the matter to arbitration. This is not intervention. This is facilitation, actual facilitation. Section 9 is a helping hand wherein if an arbitrator or the arbitral tribunal is yet to be constituted, we do have some time. It's not that an arbitrator is appointed immediately. When we send a demand notice or a lawyer notice, the next day after completion of 15 days or 20 days, we are going to appoint an arbitrator. An arbitrator's appointment process might go minimum of 30 days to maximum of 90 days if all goes smoothly. And if the court is going to be the default authority, then it adds on with some additional time. Some additional 30 days is given to the courts to appoint the, particularly the High Court, to appoint the arbitrators. Until that time, to safeguard the subject issue, the court has a role. What is that role? The court can grant interim measures, which is all listed in section 9. The interim measures of protection of the subject issue, which is very much required in most of the cases, is given to the courts before the arbitrators are appointed. Once the arbitrators are appointed, then the power goes to them based on other provisions. But until the appointment is done, to preserve, we can approach the court, and the role of court is also assisting the arbitral process. That is 9. The third one of the role of court is section 27, which is nothing but court assistance in taking evidence. Here, we have to understand that arbitrators are not at par to the judges of the civil courts. An arbitrator's authority is confined only to the parties to the dispute, as well as the documents pertaining to that particular dispute. If, assuming that in that arbitration, a third party has to be brought in as a witness, a necessity arises, or one of the party is very keen to bring that witness who's not actually part of that party or the organization wherein the disputants are involved in that case, a statutory authority, an independent authority, a third person has to be brought in. An arbitrator has no authority to issue a summons or subpoena asking that particular third person to depose as a witness before him or her or them. In such a situation, there is a role of court. The arbitrator or one of the party very well approach the court and ask the court or make the request to the court, and subject to the request, the court would give a direction to that particular witness to appear before the arbitrator. This is also an assistance given by the court. Court is assisting the arbitral tribunal to take evidence. The court is not dealing with the evidence. The court is just facilitating the arbitration process, bringing in or directing the third person to appear before the arbitrators or the tribunal. Fourth one, application to set aside an arbitral award. The most opportunity lies for us in this particular provision. Post-award, once the judgment, that is the award, is given, what would be that effect of that particular award? Either the first straight away it has to be enforced, but there is a time frame given under the same provision, that is 34, which was the fourth in that list of role of courts, wherein 3 months plus 1 more month, totally from 4 months are there for the unsuccessful party or the aggrieved party. One party is going to lose. Obviously, that party might be the aggrieved, or even both the parties might be aggrieved. Even though they are succeeding, that party might have still some grievance. Then they have right to challenge that arbitral award, and that challenge cannot be taken to the same arbitrator. That challenge has to be taken to the courts.